Hey guys, I it's been several weeks. It's been several weeks since I've been on. One is trial calendar. I was supposed to be in trial today, but we ended up working it out yesterday. But the other thing was I just haven't had much to talk about. Um, as most of you know, we handle felonies and misdemeanors in this office, and I don't often make it to misdemeanor docket call because in the hierarchy of cases, you go to district court first and then the lower courts. So usually my mornings start out in felony court on the third and fourth floors of the Galveston County Justice Center. But recently, I had a case that had been assigned to a special prosecutor from another county, and he came. We had worked out my case for a misdemeanor, and so we had to be in misdemeanor court to do this plea. And since he was coming from out of town, I, made it a point to be at misdemeanor docket call so that I could, not waste this guy's time who was coming from out of town. And here in Galveston County, there's a practice that I don't agree with in each of the misdemeanor courts, and that is when the docket or before the docket is called, the judges will tell you that you have three options if this is your first time in court. Option number one is ask to reset your case so you can have time to hire an attorney. Option number two is to request a court-appointed attorney, which means you have to fill out a financial affidavit to see if you qualify for the court to appoint you counsel. And then you're told that your third option is to speak to the DA yourself, which means represent yourself, which legally we refer to as being pro se. So it's just been happening for so long that I just kind of just forgot about it. Obviously, I think it's a horrible idea for you to represent yourself in court, and I can talk about that a little more later. But it happens every day here in Galveston County. So then the judge will start calling the docket, and people will answer option one, two, or three, and there's for me a surprising amount of people that choose option three, which is talk to the state. And as this prosecutor and I are standing there, and this was a felony court prosecutor from another county, a pretty good distance away, about an hour away, so completely different jurisdiction, and obviously not familiar with what we do here in Galveston on a daily basis. And so as he's listening to this and he's hearing people raise their hand and say, I want to speak to the DA, he looks at me and he goes, didn't we stop that? And I'm like, what do you mean? He's like, I shouldn't be talking to the defendants. And I started laughing. I said, I know. I said, nowhere else does it that I know of but Galveston County. And he's like, no, I'm serious. Didn't we stop that? And I'm like, no, it's still legal. You still have a right to represent yourself. Doesn't make it a good idea. But he was just completely shocked. And like I said, I'm just so used to it that they do it here that I just kind of overlooked it. But, I can think of so many, they call you up and the district attorney gives you a speech, or the assistant district attorney prosecuting your case gives you a speech about how they don't represent you. They represent the state of Texas. Anything you say can and will be used against you. And then they make you sign a document that you understand this and that you're waiving your rights. So that should be your first red flag, is that they want you to sign a document acknowledging that you're waiving valuable and important rights. But it happens every day. So what happens is they'll talk to you a little bit about your case. And of course, most defendants can't resist telling their side of whatever the accusation is, which is bad because now you've told the prosecutor your position, and so they can obviously later use that against you if you change your mind. Because the judge that calls the docket does tell you that if you change your mind later, you can always change your mind and hire an attorney. Of course, if you've already hurt yourself by talking to the state, it puts us in a bad position trying to clean up what may have been done before, right? But they'll talk to you about your case, and then they'll end up making you an offer. And the problem is, the offer may sound really good. The problem is they don't tell you the collateral consequences. You know, for instance, a popular misdemeanor is theft. You know, there's a whole bunch of theft cases, for instance, like out of Walmart here on the island. And so you'll think you're going to court and you've got this little shoplifting theft charge, and you think, well, it's not that big of a deal. And then the prosecutor tells you, hey, I'll tell you what, if you'll plead guilty, I'll just give you time served and a fine. Pick any number you want, $100 fine plus court costs. And a lot of defendants say, oh, all I got to do is pay a fine. I don't have to go to jail. Yep, that's it. And so that person will sign up for that plea. Now, the problem is, what the state didn't tell you is that theft is a crime of moral turpitude. And unless you don't ever plan on trying to get a job, then I guess that conviction is probably okay. But if you plan on trying to get a job with a crime of moral turpitude on your background, it's not going to happen. No one's going to hire you. They won't hire you to be a cashier because they think you'll steal their money. They won't hire you to handle their goods because they think you'll steal their goods. And so another common one is family violence, assault. Husband and wife, whatever it is, boyfriend, girlfriend, man, woman, it doesn't matter. Although I see this a lot with men, same offer you just got. Sounds great. Well, I hope you're not a hunter, because if you just took a conviction for family violence, you can't own firearms or ammunition for a certain period of time, a certain number of years after this conviction. So if you're a hunter, you just gave up your ability to hunt. Now, these are the things they don't tell you. And it's sort of like if you think about watching a trial, you've seen trials on TV and whatnot, and if you can imagine a trial where the attorney isn't objecting, isn't asking questions that matter, is trying to speak, is trying to testify rather than ask questions of the witness, and then keeps getting shut down by the judge, and you just see this attorney sitting there messing it all up. Obviously, you would think that person has a great appeal because their attorney didn't do anything and did a horrible job, and so they should be entitled to an effective assistance of counsel. Well, not if you represent yourself. And so, like I said, it's been going on so long here in Galveston County that I just forgot, didn't even pay attention. It was when this out-of-county prosecutor was looking at me going, well, what's going on here? Why are they doing this? And I literally just started laughing. And it literally happens every morning in each of the county courts in Galveston County. People are given the opportunity, and not encouraged, but people are given the opportunity to just not go hire a lawyer, not ask for a court-appointed lawyer, but here, just go talk to the state and see what they have to say, see if you can work it out. It's just a horrible idea. As I've said many times, the problem with criminal cases is that a conviction can have lifelong consequences. People have called me over the years and said, hey, I got a conviction for whatever 15 years ago. Isn't it so old that it goes off my record? And the answer is no. Once you get a conviction, with limited exception, it stays on your record. And so it's just never a good idea to go in court, without an attorney when you're being accused of a crime. And then certainly not to sit there and talk to the person that represents the state of Texas and is trying to prosecute you. I suspect that the two main reasons people choose to do this are related. One is they don't want to spend the money to hire an attorney. or two is they can't afford, or they think they can't afford to hire an attorney, and they think they can't get a court-appointed attorney. So, if you found yourself in that situation, my advice would be to ask for a court-appointed attorney. Assuming you haven't called several attorneys, and see if you actually can afford one, or work out some type of payment plan, or find a way to get counsel. If you can't, I would suggest that you apply for court-appointed counsel and see if you do qualify, because if you do, the court will absolutely appoint you a lawyer, and then you at least have someone who knows the rules of evidence, knows the rules of law, knows what you should and shouldn't answer to this prosecutor, and try to work something out for you that is, not necessarily going to impact your life, your professional license. Just, there's so many collateral consequences to a conviction that you really need someone on your side that knows those collateral consequences and is trying to avoid any collateral consequences for you in the future. And you're just not going to know that on your own. I mean, this is what we do every single day, so I know. When people come in, one of the first things I ask them when we meet is, what are your concerns about this case? And we'll go through that. And then sometimes, you have lots of people with professional license that sometimes they haven't even thought that there might be collateral consequences. Where we are with UTMB, I've represented nurses, doctors, and the doctors always know, but I've had many nurses that haven't thought about yet, oh my gosh, what about my license? And so we've many times had to find a way to resolve a case that would not impact a nurse's license. Also, with the plants so close by, most of the plants use a point system for criminal convictions. Certain convictions have higher point levels than others, and then certain plants, the worker can only have X number of points or under to be allowed into that plant as a worker. So I've found situations where I had to get creative on a way to resolve the case so that my client didn't get more points than what was allowed in the plant that he or she worked in. There's just so many things that have to that have to be taken into consideration, other than just what's a good plea agreement. And when you're representing yourself, the state of Texas doesn't care about any of that. It matters not to them. What matters to them is prosecuting you. Sure, they'll make you feel like you got a good deal, and it'll sound good, and you'll walk out of the courtroom, but now you've just done something that could impact your job, your license. And so, I wish that they would stop this practice. I remember many years ago when I did a lot more work in Harris County, there would every once in a while be someone in the audience who wanted to represent themselves, and the judge would call them up to the bench and show them the Code of Criminal Procedure and the rules of evidence and say, are you familiar with these books? And the defendant would always say no, and go through a whole litany of reasons why you shouldn't represent yourself. But we don't do that in Galveston County. In Galveston County, if you want to do it, go ahead. And I guess it's an efficient way to move the docket. I guess when you've got 40 people in the audience, you want to get through your morning as quickly as possible. I'm not sure what the rationale is, but I strongly discourage anyone from representing themselves. Kind of a funny side story. As many of you know, Katie Jo Muncie used to work here in my office. She's now up in Austin, Texas. But when she was a prosecutor across the street, I would sometimes get bored in the mornings when I was done with my docket, and I would go sit near enough to her to hear her talking to pro se defendants. And so I would heckle her, so to speak. When she would be talking to a pro se and make him an offer, I would chime in and say, for instance, on the theft, she's not telling you that that's a crime of moral turpitude, and if you take that deal, you're not getting a job anywhere. and she would always get irritated with me, but she kind of played along because she knew what I was doing was right. She just didn't like it because it was messing up her morning and making her stay longer in court. But I've always been against this practice that we do in Galveston County, or that the judges do in Galveston County. There's sort of a running joke in a court, and I'm not going to say the court, but they would go through the three options. And one day, the judge was not on the bench. It was a court staff member calling the docket. And so when she's done with option 3, I said, well, or there's option 4. And the court staff member looked at me and I said, well, option 4 is hire Mark Diaz. And, you know, everyone got a big laugh at it. And so every once in a while, that person still will call me option 4. It's just kind of a little inside joke. But it is something that probably we need to address as a defense bar at some point in the future here in Galveston County, because, you know, you've got people taking deals without legal advice on matters that literally can impact their future. So, like I said, I haven't had a topic good in a couple of weeks, and when this happened the other day, it just kind of made me think, well, that's a good thing to talk about. So hopefully I'll be back next week. Y'all all, hey, Paula, Mom, I hope y'all have a great week, and we'll see y'all next week, hopefully.